I'm just going to start out by thanking folks for joining us today for part 3 of our community legal education workshop series on guardianships. Today, we'll be focusing on guardianships of incapacitated persons. Our presenters will be Carolyn Hetzner, the Senior Manager for the Court Service Centers, and Geraldine Gruvis Pizarro, who is one of the family law and guardianship supervisors for the Volunteers Lawyers Project of the Boston Bar Association. These presentations are being recorded and will be made available to folks on YouTube at the De Novo Center's webpage, as well as on the Guardians and Other Caregivers page on masslegalhelp.com. At the end of the presentation, we will have an opportunity to answer questions that folks may have. However, we want to stress that the purpose of this workshop is to provide legal information, not legal advice. So we cannot provide you advice on your specific cases or circumstances. However, we can provide general legal information to help you navigate this process should you or someone you're working with find yourself working with someone who's in need of a guardianship of an incapacitated person. For that reason, when you put your questions in the chat, we will be removing any personal information that may be included in the questions to protect your confidentiality. So with that being said, I'm going to turn it over to our presenters to begin the presentation.
Hi, good evening, everyone. My name is Carolyn Hetzner, and as Tanisha said, I am the Senior Manager for Court Service Centers. We have the Court Service Centers assist pro se litigants with both types of guardianships that we're going to be we'll be talking about the guardianship of adult today. Geraldine and I both fill out these papers quite a bit, and there are quite a bit of papers to fill out, and it's very confusing. So we hope that the information that we provide today can alleviate some of the confusion in the paperwork. Okay. So the first thing I want to go into is to explain what a guardianship is, with talking about some of the terms to begin with. The terms can be often confusing, and there are a ton of terms that are used on the documents themselves. The first term is petitioner, which is the term used to refer to an individual filing for guardianship over a person. The petitioner can be anyone, but generally the petitioner will be the person that is seeking guardianship themselves. The respondent is a generic term that refers to any subject of a guardianship. And I do realize that these terms were pulled off of the guardianship of minor training. So we will correct the slide before we post on the website. Guardian is the term used to refer to a person who has been appointed by the court as a guardian over a person. And notice is the requirement that a person filing for guardianship must provide or attempt to provide to an interested party, to a person who needs to know about the proceeding. And an interested party is a person with a legal interest in the case. And in most cases, this will generally be a parent, a sibling, another legal guardian, or someone that is directly affected by the case. What is guardianship? A guardian must be appointed by a probate and family court. A guardianship grants a person authority to care for and to make decisions on behalf of an incapacitated person. The court must approve any resignation or any order of removal of a guardian. You can't just stop being a guardian because you decide to do so. And all interested parties must receive notice. There are two types of guardianship. There's guardianship of a minor, which is for a child under the age of 18, and guardianship of an incapacitated person. The guardianship of a minor is generally when there is an absence of a parent, a death of a parent is unable or unfit to care for a child. And a guardianship may be unnecessary if the caregiver has a parental authorization or parental absence is short-term. On the other hand, a guardianship of an incapacitated person is for a person who, one, has an incapacity or an intellectual disability or a mental illness. The guardianship removes some of the incapacitated person's autonomy and decision-making ability, and the guardian steps into the shoes to make those decisions. A guardian's financial powers. A guardian can become the representative payee and collect the respondent's Social Security benefits from the Social Security Administration. They can learn of assets and income, but will not have the authority to spend or distribute any of the income. And a guardian can collect up to $5,000 a year for a minor. A conservatorship, on the other hand, is to manage someone's money, where a guardianship generally manages a person's health and well-being. A conservatorship will manage someone's money. They can also be used if someone needs the authority to bring a tort action on behalf of a protected person. The protected person owns property that needs to be conveyed or sold. The protected person is a beneficiary in an estate. And the filing fee for conservatorship is generally not waived by the court, whereas a guardianship itself doesn't cost any money to file and only costs money to serve and money for the citation to issue. There are various grounds for a guardianship. There's incapacity and intellectual disability. A person must be, quote unquote, incapacitated. And what that means is a person, for reasons other than advanced age or minority, has a clinically diagnosed condition that results in the inability to receive or evaluate information or to make or communicate decisions to such an extent that the individual lacks the ability to meet essential requirements for physical health, safety, or self-care, and even with the appropriate technological assistance. And here's the law that covers that. Or a person must be intellectually disabled. A person with a significantly sub-average intellectual functioning, it's usually an IQ of 70 or less, with limitations in one or more of the following skills: communication, self-care, home living, social skills, community use, self-direction, health and safety, and work. Previously, the term mental retardation was used for an intellectual disability, but that has been removed from all Massachusetts statutes and has been replaced with intellectual disability instead. Why would someone seek a guardianship for an incapacitated person? There are various reasons why you would do so. And a person is unable to make decisions regarding their own health, safety, and self-care. Something happens to a person and they're now hospitalized and they need someone to make a decision for them. Unfortunately, in Massachusetts, there is no statute authorizing medical providers to look to a family member or next of kin to make decisions. And there's no indication of who should be given priority in decision-making if the person does not have a healthcare proxy. So having a healthcare proxy is extremely important, but we often find that folks don't have them. And then they come to Geraldine and I because their family now needs to seek a guardianship over them. They need decisions to be made if there is a disagreement among family members regarding a course of treatment, or they need to make extraordinary medical decisions such as administering antipsychotic medication, discharge to a nursing facility, or amputations. Guardianships are designed to balance protection of the individual with his or her independence and self-reliance to any extent possible. Examples of when a guardianship might be necessary, and these are the things that Geraldine and I would see the most between the Volunteer Lawyers Project and the Court Service Center. We have elderly parent with a degenerative health condition and cannot consent to treatment or placement in a nursing facility, and there is no healthcare proxy. A family member who has suffered a traumatic brain injury and cannot consent to participation in ongoing medical care or rehabilitation. There's a disagreement among family members. And a disabled child is turning 18 and parents can no longer make decisions without a court authority. So this one you want to be extra careful for if you are helping someone fill out guardianship paperwork. If the child is 17 turning 18, it would fall under the guardianship of an adult if the paperwork is being filled out by a parent. When is a guardianship unnecessary? And we also have to have these difficult decisions with folks a lot of times talking about how the court may not grant them a guardianship because of these reasons. A person has a physical or other disability but retains the decision-making ability. A person has a healthcare proxy and there's no disagreement over care plans. A healthcare proxy provides a lot of power to someone who has been designated as the healthcare proxy. The person is making poor decisions or decisions in which the family disagrees, but the person is competent to make decisions. I think the example that we use the most is that grandpa is elderly. He now has a younger partner and he's spending all of his money on her. Just because he's spending all of his money does not make him incapacitated, and he likely does not require a guardianship. He's allowed to do with his money what he wants. And a person retains the ability to make decisions, but only with assistance, technological or medical, etc. There is a preference in the court for limited guardianships for incapacitated persons, as the court will give only as much authority as appears necessary to alleviate the problem caused by the person's incapacity. They don't want to do a general guardianship if a person is able to make some decisions, and the court will designate which decisions the guardian is allowed to make on behalf of the incapacitated person. The court encourages the development of maximum self-reliance and independence of an incapacitated person, and makes orders only to the extent necessary by the respondent's limitations. And a court may, on its own motion or motion of the IP or other interested person, limit the powers of the guardian and create a limited guardianship. Now, there's lots of limitations on guardianships that I'm going to try to go through. Nursing facilities is the first one. In general, a guardian does not have the authority to admit a person to a nursing facility without a specific court order. So the guardianship in and of itself does not allow you to do just anything for the IP. It is limited in the fact that you need a court's approval to put someone in a nursing facility. The court must first determine that the admission is in the person's best interest. The exception to this is if you're trying to put somebody in a nursing facility for 60 days or less, a guardian may be allowed to do so, and they fill out something called the notice of intent to admit into a nursing facility, and they would need the recommendation of an authorized licensed healthcare provider. They would need not have the objection of the incapacitated person. Written notice of intent to admit must be filed by the guardian with the court that appointed them as guardian, and a copy of the notice has to be served in hand on the incapacitated person, nursing facility, and the counsel, if any, for the incapacitated person. The incapacitated person must be represented by counsel. Commitment to a psychiatric facility. We see quite a few people coming to us trying to get guardianship in order to do this procedure. Unfortunately, a probate and family court cannot admit someone to a psychiatric facility. That is done by the Boston Municipal Court or a district court, and that is done through something called sectioning. The duties of the guardian are fairly simple. They are responsible for the respondent's care, support, education, health, and welfare. They should always act in the respondent's best interest, and they shall exercise reasonable care, diligence, and prudence. A guardian must preserve the person's right, freedom of religion, exercise authority only as necessary by the incapacitated person's mental and adaptive limitations, and encourage the person to participate in their own decision-making. The immunities of the guardian is not personally liable for the respondent's expenses, and they are not liable to third parties for the acts of the incapacitated person by reason of the relationship as guardian. Liability of a healthcare proxy. No person acting as an agent pursuant to a healthcare proxy shall be subject to a criminal or civil liability for making a healthcare decision in good faith pursuant to this chapter. All right. Mental illness and treatment is another limitation that a guardian will need specific court authorization for. Respondents who are mentally ill are sometimes treated with antipsychotic medications, and treatment with antipsychotic drugs requires special court authority. It's called Rogers authority, and a Rogers authority must be granted along with the guardianship and need to be in place, which requires special forms and procedures. And then finally, substituted judgments are also something that you need specific court authorities for. A court authorized treatment to which the respondent would consent if not incapacitated. So basically, if the person did not have their disability, they would make the same decision that the court is authorizing. Counsel is provided for the respondent in this situation. And I have to say that counsel, when you're seeking to admit someone to a nursing facility, if you're seeking to administer antipsychotic medication and any other substituted judgment, counsel will be automatically appointed by the court. Best interest versus substituted judgment, just the difference between what the two are. Best interest is the guardian must make the decisions in the best interest of the incapacitated person regarding ordinary, customary, and usual medical treatment. They can consent to most non-invasive, non-experimental procedures that are life-sustaining or beneficial, taking into consideration the health, medical, and safety needs of the incapacitated person. A substituted judgment, on the other hand, is more extensive. That would include invasive medical procedures like amputation, antipsychotic medication, electroshock therapy, and sterilization. Those are substituted judgments that you need specific court authority in order to make those decisions for the respondent. And now for the guardianship process, I'm going to pass it off to my friend Geraldine, who will go through the next portion of the presentation.
Sorry, I was muted. I now have control, right? Yes. All right, so now that we understand sort of all the complicated terms of the guardianship, we know what the best interest of the IP is, we know what substituted judgment is, we're going to talk about the guardianship case timeline. So now we're going to go file into the court all the paperwork and everything that is needed. I will start by saying that there is a lot of paperwork that needs to be filled out for a guardianship case. Because we are limited on time, I'm going to sort of zip through the paperwork, go briefly over what is needed, but we are providing some resources at the end of the presentation so that you know where to go to for assistance with filling out these forms. The most important thing that I would like you to take away from this is the medical documentation, because those are the essential and necessary documents that you need before filing a guardianship of incapacitated person. So let's get started. So the guardianship case timeline. You want to determine who is going to petition and where they can file. So anybody who has an interest in the incapacitated person can file a petition for guardianship. You are going to file the guardianship petition along with the accompanying documents, and we're going to go through what those are. We're going to talk about the post-filing stage, and very important and essential for the case to go forward, complete service of process. So this means telling those interested parties, which Carolyn already talked about, that there is a case that has been presented in court to get guardianship over the incapacitated person. Service of process is essential. If this does not happen and you don't tell the interested parties about the case that has been filed, the case is not going to move forward. So it's really important to keep that in mind. Even if the incapacitated person has an estranged child and doesn't have any current address for them or doesn't have any contact, they're still an interested person in the case, and they will need to be served by publication. And this is for estranged children, estranged spouse, sibling, etc. And then the hearing, you need to attend the hearing, obviously, once you get notice of that from the court. And then there is a post-appointment reporting to the court, and we're going to talk about that. And that just means informing the court about the guardianship, what the treatment is for the incapacitated person, and that the incapacitated person is still in need of a guardianship, and what is being done to maintain that treatment and that guardianship in place. So who can file and where we're going to file? So an incapacitated person or any person interested in the welfare of the person alleged to be incapacitated may petition the court for determination of incapacity in whole or in part, and for the appointment of a limited or general guardianship. So as Carolyn stated, the courts do prefer a limited guardianship because a guardianship will take away part of a person's autonomy. We want to talk about limited guardianships, and there is a page that lists examples of how that guardianship can be limited. That is part of the decree and order of the guardianship paperwork. There are priorities in who can be named a guardian for the IP. So the court appoints as guardian the person nominated in the respondent's most recent durable power of attorney, if they have one. And if they don't have one, then the following people have priority in this order: the spouse of the incapacitated person, or a person nominated by will or other writing or deceased of the deceased spouse, the parent of the incapacitated person, or again, a person nominated by will or other writing of the deceased parent, or any person the court deems appropriate. So if there's nobody who actually has priority, the court will appoint a professional guardian. So the court may select a person best suited to serve and may, acting in the respondent's best interest, pass over a person with priority and appoint a person with lower priority or no priority. And this would happen in the case if there is somebody that has priority, but the court finds that they're not suitable, or there has been a case against them for negligence against the incapacitated person, then the court can appoint somebody else. So again, who may not be a guardian? The court shall not appoint as guardian any person who is currently being investigated or has charges pending for committing an assault and battery that resulted in serious bodily injury to the respondent or neglect of the respondent. There is a carry that is run for the proposed guardian, which is a court activity record information, which will show any type of investigation that has happened or that may be pending. And this is the statute under which you can find this. And so when we talk about proper venue, that just means where am I going to file? And that's important because if you file in the wrong venue, the case is going to be dismissed. So you want to file in the county in which the respondent resides at the time that the petition is filed, the county in which a will nominating a guardian was or could be probated, or an IP is admitted to a facility pursuant to court order. So if the IP is already in a facility in Suffolk County, but you live in Middlesex County, you're going to file in Suffolk County, which is where the IP is admitted. So filing the petition, again, there's a lot of paperwork involved with this, so we're going to go through the checklist of the initial filing. You're going to file the petition for appointment of guardian for incapacitated person, and this petition has about 6 to 8 pages, if I'm not mistaken. You're going to file the verified motion for temporary guardianship, if applicable, and I think we're going to talk about how and when this is applicable, but this is not necessarily always necessary. This is only filed when you have an emergency and you need to have a temporary guardianship issued before the permanent guardianship. You're going to file the paperwork for the bond, a military affidavit stating that none of the interested parties are currently serving in the military. And if applicable and you are of low income, you can file a fee waiver. And this just asks the court to waive any filing fees, any cost of service or service by publication. So there is no filing fee for the guardianship petition, but there are, there's like, if you have to serve by publication, that's a cost, and then the citation and the letters of guardianship as well. You're going to file the medical certificate or clinical team report, and we're going to go more into this later, depending on the condition of the incapacitated person. You will need either a medical certificate or a clinical team report. These are essential. Without these documents, you can't file the petition. So it's really important that you get these first. And those, the documents that have an asterisk means that those need to be signed by the guardian or the client. So as I stated, I'm going to sort of zip through these, but I just want you to have an idea of what the petition looks like. In this case, this is the first page of the petition, and what we have highlighted here is you have to tell the court if the respondent is or is not intellectually disabled. And the reason for this is because depending on this question is what the medical documentation that you're going to need. So if the person, sorry, I'm going to go back. If the person is intellectually disabled, you're going to need a clinical team report, and we're going to talk about that a little bit later on. You're going to check off who, about the information about the proposed guardian and why he or she has priority of appointment. And if they don't have priority of appointment, why they would be the best person to be appointed as guardian for the incapacitated person. And then we're going to talk about, you're going to check off if this is going to be a limited guardianship or a general guardianship. And as Carolyn stated, the court does prefer a limited guardianship because we want to make sure that the IP maintains some of their autonomy. But there are cases when the person is just so intellectually disabled that there is no other way but to get a general guardianship, and that's fine. And that's usually going to be documented in the medical documentation. So if it's a CTR, there's going to be information in there about why this can't be a limited guardianship. This at VLP, I don't know, Carolyn, if you do this as well, but we call these the box people. And the box people are the interested parties. And why do they call them the box people? Because they're all put in boxes. And sometimes you have 4, 5, 6 siblings, and you need more than just the one page that they provide in the petition, and that's fine. We have a lot of copies. But the box people are important because these are the interested parties. These are the people that you have to notify of the petition that is being filed. You want to make sure that if there's a parent, if the parent is there, the siblings, if there are children, they want to be there. You need to have their addresses, their phone numbers. If you don't, then you can put in parts unknown. If you have a last known address, I wouldn't include it in here. I would include it in the motion for service by alternate means, which you would need to file. And then if they put in the relationship, who they are, if they're a minor or if they're incompetent and have their own guardianship. Sometimes we have the petitioner come in and they're already the rep payee for the incapacitated person. You want to make sure to include that information. You need to include information if there's a healthcare proxy or a durable power of attorney already in place. And this, I got a little bit ahead of myself, but this is where you would put that information. And then this is the request for relief, right? What are you asking the court to do? So in this case, you are seeking specific court authorization to admit the respondent to a nursing facility, if that's what you're looking to do, to treat the respondent with antipsychotic medication. So as Carolyn said, that requires specific court authorization with a treatment plan and additional paperwork that needs to be filed. One thing that I always like to include that people don't always think about, specific court authorization to request and renew a passport. So it might be that you're not traveling today, but sometime in the future you might want to travel. And if you don't have that authority, you're going to have to go back to court and try to get it. So I always just include it in, allow the petitioner or the guardian to renew and request passport for an incapacitated person as needed. And then you just have that authority, and then you can go travel and see the world. These additional signatures in the back of, at the last page of the petition is for interested parties who will assent to the petition. What that means is the interested parties that need to be notified, the father, the mother, the siblings, the children, they can assent to the petition that is being filed by signing the last page of the petition. That means that they're assenting, they're saying to the court, I'm okay with this, go forward, I don't need to be notified of anything. So if that is the case, you can fill out the petition, you can have them sign off on it and file it with their signature, and you should be all set. You wouldn't need to provide notice to those interested parties. This is the page that I was referring to about the limitations to guardianship. So this is the last page of the decree and order. The decree and order is what the judge signs, saying that this guardianship is approved, and I'm naming Jane Smith to be the guardian of Joe Smith. The limitations page is, to me, is really important because it really just has some very good examples of the things that an IP can do, even with supervision. And sometimes I like to kind of play around with it, and we call it doctor the form, to make it very specific to the incapacitated person. So there are things that you can see care of self. So if the person can be responsible for their own bathing, dressing, toileting, and dental care, that's something that they can do on their own. Even that qualifies as a limited guardianship. One thing that is really important is the right to vote. That's a civil right, a civil liberty that we all have and shouldn't be taken away, right? Even if you understand that the person doesn't have the ability or the capacity to understand, it's their right. And if we can maintain that, and I know that when counsel is appointed for the incapacitated person, CPCS counsel is really just hard on that, and they really like to see, even just if you just check off the right to vote, it's a right that we're keeping for the incapacitated person. So it's something that you really want to keep in mind. So the verified motion for temporary guardianship. This requires the filing of the petition, which is the whole list of paperwork that you want to file, and a verified motion for temporary guardianship. There's no petition for the temporary guardianship, and there's no motion for permanent guardianship. And I know that it's really complicated, but you have to understand that the whole process starts with a petition. You can only file a motion when there's a pending case, right? So I think that's the easiest way to explain it. If you file a verified motion for temporary guardianship, this will require proof of risk of substantial harm to the health, safety, or welfare of the respondent. What this means is you have to prove to the court that there is an urgent need for you to get this guardianship before we wait out the whole process of getting the permanent guardianship. This temporary guardianship will expire after 90 days, but it can be extended by the court on a 90-day period. And this is just the form for the verified motion for appointment of temporary guardian. And you can see that you have to state an emergency exists requiring the appointment of a temporary guardian. And you have to put in the nature of the circumstances that requires the temporary guardian. So in this case, respondent just turned 18, and due to his developmental delays and low IQ, he requires the guardian to make decisions for him to ensure his safety. A lot of times, sometimes it's registering somebody for a special needs school, an emergency medical procedure, those types of things. That's what we usually see for temporary guardianship. And again, in this case, you're going to ask the court what you want them to do. So the moving party further seeks specific court authorization to do the following. And it's always important also, you want to make sure that if there is an existing healthcare proxy, you want to make sure that you check off that the court should revoke the existing healthcare proxy if that's something that you want to do, because if there is an existing healthcare proxy and you are the guardian and that healthcare proxy is not revoked, then you're going to have different opinions about what the guardian wants to do and then what the healthcare proxy wants to do. So that's always really important to keep in mind. And I'm sorry, I should have mentioned that before. There's a lot. The bond paperwork. So you must file a bond, the bond paperwork. A bond you need to file a bond if filing for temporary or permanent guardianship. And this is just surety, and it is required on the bond unless the court determines that it is in the respondent's best interest to waive surety or to require additional sureties. This is just a guarantor of payment or performance if another fails to perform. Now, these are usually routinely waived on all guardianship bonds, but they are not waived on conservatorship cases. The reason for that being is usually a guardianship, there's no money to manage, right? And so as Carolyn stated, there's a difference between guardianship and conservatorship. Conservatorship is about managing the finances. So there is money in that case. So those, the bond on conservatorship cases will not be waived by the court. When you fill out the bond paperwork, you're going to check off that you want to file without sureties. And in this, you have to put in more or less the value of the real estate or personal estate of the incapacitated person. And the fiduciary name is going to be the guardian. And the guardian is going to sign as fiduciary number 1. There are 2 spaces. So sometimes if you want to have a co-guardian filing the petition for guardianship, that's fine. Then you will both be fiduciaries and you'll both have to sign the bond paperwork. The military affidavit. We're very lucky that we have a new military affidavit form as of last week. It's a little bit more complicated than the one that we used to have, but here we go. It is now a 2-page form. You have to list, again, the interested parties. So everybody who needs to get notice of the petition. So mother, father, siblings, children, all the box people, we're going to put them in here. We're going to list them, and then you can just check off on page 2 just a personal statement saying that to your personal knowledge, none of the interested parties are currently or have ever served in the military, unless that is not the case. And if somebody is in the military, then you have to check off that they are in the military, and then a whole bunch of other process has to happen with service, but we're not going to get into that today. And then we have the affidavit of indigency, and this is again the fee waiver. So you're asking the court to waive the fee so you don't have to pay anything. Again, there are no filing fees for the guardianship petition, but there are associated costs. So we have the $15 fee for the citation, $25 for each certified copy of letters of appointment. And these are important because that's what you're going to take at the end of the case when guardianship has been granted. You're going to take those, you keep the originals, and you make copies to give to the medical providers, the PCAs, whoever needs to know that you are the guardian of the bank if needed, etc. Cost of service of process, and that's going to vary if it's going to be service by publication in a new newspaper or if it's going to be constable or sheriff. There is a $75 filing fee for filing a bond with sureties. And a person filing is eligible for a fee waiver if they receive public assistance. So most of the cases that we see are clients who are on Mass Health. So that will automatically get you a fee waiver approval, except if you're in Norfolk County, you have to also file the supplemental to the affidavit form, which is sort of a mini financial statement. But again, if you have any questions about filling out these forms, please contact the Court Service Center or Volunteer Lawyers Project, and we'll be happy to help you with that. Person filing is also eligible if they have a net income of less than 125% of the federal poverty guidelines or is otherwise unable to pay any fees. And again, in this case, they would need to fill out the supplemental to the affidavit of indigency form. And this is the form, an example of the form. On the first page, you're going to include your information, the case name and number at the top. Name of applicant, that would be you, the person filing the petition and the person asking to not have to pay any of the fees. You're going to check off one of the boxes, the applicable boxes, so either A, B, or C. And then you want to make sure that on section 2, you check off all the fees that you're asking the court to waive. So filing fee and any surcharge, fees or costs for serving court summons, and other fees or costs you want to put in, this is really important, service by publication and letters of appointment. You want to add that to make sure that that's also covered. Required medical documentation, and I would say that if you take anything away from this presentation, this is the part where you really need to pay attention. Medical paperwork will focus on 3 elements: clinically diagnosed condition, decisional impairment, and functional impairment. The medical certificate is an evaluation of the proposed incapacitated person, and it must have happened within 30 days prior to filing the petition. So this document is only alive, if we can say it that way, for 30 days. And this is so important because getting a medical provider to fill out these forms is really difficult because they're extremely busy and it's hard to get an appointment. And you want to make sure that you, once you get that medical certificate, you file immediately. So again, the medical certificate is valid only for 30 days from the date of that signature. If you come to us day 31, we're going to say, no, you need to get a new medical certificate. And that's just going to delay anything that you have to do with the guardianship. The medical certificate is good for a fluid medical condition. So what does this mean? It means something that is temporary or recent. So a good example that my colleague Stephanie Biggs always used to say, we're Red Sox fans. I'm not, but she is. So we're at a Red Sox game and we're just having a really good time. Somebody hits a home run. Stephanie gets hit in the head. She's out, knocked out cold. She now can't do anything. She can't make any decisions. She has a traumatic brain injury. That is a good reason to get a medical certificate. I'm going to go get a guardianship because she now needs somebody to make decisions on her behalf. She's conked out. That was a great home run. That's a fluid medical condition. We expect her to get better, but at this time, she needs a guardianship. The clinical team report is something different. So the clinical team report This examination must have taken place within 180 days of the filing of the petition. So this gives us about 6 months, but it's 180 days. So you have to make sure that you're not counting 6 months. 180 days. It is valid forever so long as the petition and the CTR is filed within those 180 days of the earliest signature. The most important thing here is the earliest signature. So this clinical team report has to be signed, has to be signed by a psychologist, a social worker, and a medical doctor. So you have 3 medical providers who are filling out this form. The 3 medical providers are not going to see the incapacitated person on the same day. So one sees the incapacitated person in January, one sees the incapacitated person in February, the other one sees them in March. You have 3 months already, but the earliest examination date was in January. So if you're coming to me today, May 20 something or May 18th, I'm looking at the date of January. We're still good. We're still within those 180 days, but I'm not going to be looking at the March date. So it's really important that you keep that in mind when you're reaching out to the medical providers, knowing that you are on a timeline. You have a good amount of days, but you are on a timeline. And then the clinical team report is good for intellectual disabilities, anything that has been since birth or early childhood. We mostly see this with people on the autism spectrum. So the medical certificate is completed again and signed by a physician, licensed psychologist, psychiatric nurse, or nurse practitioner. So this is only one signature, and it can be any of these medical providers. The medical certificate includes the description of the person's cognitive and functional limitations, the evaluation of the person's mental and physical condition, prognosis for improvement and treatment recommendations, because again, this is a fluid condition, which we hope is going to get better, and the date of the examination when it took place. Again, only valid for 30 days. And this is just a blank sample form of the medical certificate. And you can see on this page, they have to state who they are, personally examine what they're, so they're registered, in this case, a registered physician, specializing in neurology, examine the IP on who resides at wherever he resides, and examined him on January 24th, 2020. So obviously this is way past 30 days. We would need a new medical certificate in this case. The clinical team report. It's used only when the respondent has an intellectual disability. It is completed and signed by 3 people, a licensed physician, a psychologist, and a social worker, who are experienced in the evaluation of intellectually disabled persons. The hardest thing about this is the social worker. I've noticed with our clients, it's difficult to get a social worker, especially if it's a young adult transitioning into about 18 years old. But without that signature, we're not going to be able to file. And again, you must file the petition within 180 days of the earliest examination date. And this is just a sample form of the clinical team report. And on the first page, you're going to see that it has all of the dates of examination. So who examined the IP, licensed psychologist, licensed social worker, and the doctor. And then on the last page, it's going to include the signatures for all of them. The medical certificate affidavit may only be used to obtain or continue a temporary guardianship. It can be used to obtain permanent guardianship only if the IP's counsel does not object. So in this case, the IP would be assigned an attorney. It is used to replace an expired medical certificate, which again expires after the 30 days. And it must be signed by the same persons who are qualified to sign a medical certificate. In this case, the IP must be medically stable. And this is, excuse me, a blank form for of the medical certificate affidavit. So when we talk about impoundment, the guardianship court files, just like any court record, is open to the public, except that clinical team reports, medical certificates, and physicians' affidavits are impounded by the court and kept in a separate file, just like financial information is also kept separate in other types of cases. A person can file a request of interested party to access impounded medical information, but if a petition for guardianship is denied, then the whole file is impounded by the court, and nobody would be able to access it. I don't know why it just repeated itself, sorry. So the appointment of counsel for any respondent. The court must appoint counsel for the respondent, and again, this is the alleged incapacitated person, if the respondent or someone on his or her behalf requests appointment of counsel, or if the court determines that the respondent's interests are or may be inadequately represented. Sorry, I'm having issues with these. The court appoints when special authority is requested. So in the case of substituted judgment cases, the court will appoint counsel for the respondent through CPCS counsel. Sorry, so through CPCS. Anyone interested can file a request for counsel. And this is under Mass General Laws 190B, Section 5-106. And so now we're going to talk about substituted judgment cases, and these are Rogers guardianship. So Carolyn already touched upon this briefly in her presentation. And so substituted judgment cases are where guardianship is sought, including a request for special authority, which requires substituted judgment. This is for extraordinary measures that are considered particularly intrusive, risky, or restrictive of the IP's personal liberty. The court will only authorize treatment to which the IP would consent if the IP was competent, taking into account all of the factors and concerns. And in this case, counsel will be appointed for the incapacitated person to ensure that his or her interests are being looked out for. Additional medical documents that will be needed for substituted judgment cases are the clinician's affidavit and medical certificate if one has previously expired. There is case law regarding substituted judgment cases with a list of treatments and procedures. So anything that has to do with antipsychotic medication, these are the ones that we see most frequently. A lot of intellectually disabled adults are treated with antipsychotic medication. So these are the most common ones. That is something that requires substituted judgment. Sterilization is something that requires substituted judgment. Abortion, initiation or removal of life-sustaining mechanisms, and electroconvulsive therapy or psychosurgery. So these are all examples of cases where substituted judgment is required, so special authorization from the court needs to be sought by the guardian. So you may be the guardian already for an incapacitated person, but if any of these situations come up, you need to go back to court and get specific authorization to get this done and to be able to authorize such treatment. The most common substituted judgment authority requested is the administration of antipsychotic medication. The person appointed as Rogers monitor could be the same as the guardian or someone else. So we call the Rogers monitor the person who is going to ensure that the incapacitated person gets that medication. The judge signs findings of fact and conclusions of law and a treatment plan lasting only 1 year. And so the authority only lasts for that 1 year and has to be renewed annually. The date of expiration of the treatment plan is the court date of the next year. And just so another tip of information and just a little heads up, when you're doing submitting treatment plans to the court for antipsychotic medications, try to have the doctor include a dosage range for the incapacitated person, because sometimes, depending on and I'm not a doctor, depending on the condition of the incapacitated person, the treatment might change, and you might get 5 milligrams of some antipsychotic medication today, but in a couple of months, we need to up that to 10 milligrams. As the Rogers monitor and the person with the authority to authorize this treatment, you can't just authorize to go up to 10 milligrams unless you have that special court authority, that specific court authority. So you want to make sure that the doctor, if possible, includes a dosage range. So saying, I'm going to treat Joe Smith with 5 milligrams to 10 milligrams of fill in the blank of whatever medication is needed. And that's going to save you some time to go back to court. If all annual extension paperwork is filed with the court prior to the date, then that can be administratively allowed. But these are the post-judgment issues that we were talking about before. You have to let the court know what's going on with the incapacitated person, and you have to file the annual paperwork to renew that Rogers authority for the guardian. So now we talk about the post-filing stage. So again, interested persons can sign the back of the petition to indicate that they assent to the petition, and that would be pre-filing. They can also sign a separate general assent. So if you have somebody who would assent to the petition, but they're not here and they're not able to sign, they're in another country, you can send them a separate general assent form to sign, and then you can bring that back and submit it to the court. The respondent does have a right to attend the hearing. They have the right to be present. They have the right to be represented by counsel. They have the right to be present evidence, cross-examine all witnesses, and request that the hearing be closed for privacy purposes. Anyone who has an interest in the case may file an objection to a temporary or permanent guardianship by filing an appearance and objection. If objections arise, then that means that the case will become contested. They also have to file an affidavit with that appearance and objection. They have 30 days to do that. However, most cases do settle before going to the judge, so that's always good, but you do have that right if you don't agree to the petition that is being filed. So post-guardianship monitoring by the court. Now we have the guardianship in place, everything is good. The monitoring by the court means that the guardian of an incapacitated person must file a care plan report within 60 days of their initial appointment and annually thereafter. So every year after on that anniversary date, they have to file that report. The guardian must notify the court if the incapacitated person becomes capable of exercising rights that were previously limited. If the guardian does not comply with filing these care plans, the court can issue a notice of non-compliance for failure to file timely reports, and they could actually remove you as guardian and appoint a professional guardian. So you really want to make sure to file those reports every year. Termination of the permanent guardianship. The guardianship will terminate upon the death of the guardian or upon the death of the incapacitated person, upon the resignation of the guardian with court approval. So you can't just resign to be a guardian. It has to be approved by the court. The removal of a guardian by the court. So again, the court, if, for example, you don't file those annual reports, the court could remove you. So removal of a guardian could happen upon filing of a petition by the respondent or any person interested in the welfare of the respondent, or termination of the guardianship because of the determination that the IP is no longer incapacitated. And that is a very high bar and very difficult to prove too. The forms, all of the forms that you need are available online on mass.gov, and this is the website where you can find them. There are a lot of forms to be filled out. We went through some of them. It is a little bit overwhelming. This is the governing statute that states everything about guardianship, if you want to read it. Volunteer Lawyers Project has guardianship clinics, and we run these in Suffolk County, which is in Boston, in the Suffolk Probate and Family Court. We use Carolyn's space at the Court Service Center. Every first and third Wednesday of the month, we're there from 9 to 1. It's a walk-in clinic. You're welcome to come in. And then we do have guardianship clinics at the Middlesex County Probate and Family Court in Woburn, and that happens on the second and fourth Thursday of the month from 10 a.m. to 1 p.m. We are also still doing Zoom clinics, and these happen on the second and fourth Wednesday of the month from 9 a.m. to 2 p.m. So those folks who just really can't get to Boston or Woburn, we do provide a Zoom clinic to be able to help you. This is a list of other resources that you can call for assistance. Lawyer for the Day programs, those are really helpful. Different counties have them, and then they just have a lawyer there for the day who can help you fill out forms, give you some advice, and sort of guide you on what the process is. The trial court resources include the Court Service Center and the Trial Court Law Libraries. They are all great resources, highly recommend them. And for more trainings on guardianships, you can visit the De Novo YouTube page. Tanisha, come back to me. This is the third series in our workshops. So we did alternatives to guardianship, guardianship of minors, and we are finishing up with guardianship of incapacitated persons. And we really hope that these have been helpful. This is what we wanted to do to ensure that pro se litigants get some information on how to do this on their own, but we're happy to help if you still need that. So that's it for me. And I think I'm going to open it up to questions if we have them.
Thank you both very much. So I just have a couple clarifying questions, and if any folks that are on the call would like to add questions to the chat, please feel free to do so. So I just wanted to clarify, I know that you stated that there were some specific permissions required to have people be admitted into nursing homes or psychiatric facilities. Are those same special permissions required for like group homes for folks with intellectual disabilities, or would that be covered under a general guardianship?
That is a really good question. It should be covered under a general guardianship. I did have a client recently come in having issues because the special group home was not accepting it. But it was only because they checked off one little box in the limited guardian. So it wasn't a general guardianship, it was a limited guardianship. But even with just that one box checked, they were like, it's not a general guardianship, so we can't take this. So it should all be covered under the general guardianship.
Okay. Thank you. And then you had also mentioned the specific things that would disqualify someone from being a guardian, but you also mentioned that the court has access to the CARI, the Criminal Activity Report record or record index. Or the question is, does having a criminal record in and of itself automatically disqualify someone from being a guardian, or is it just those specific ones that lead to that automatic disqualification?
It would be those specific ones. So anything that is criminal related to the IP, that would disqualify you as being a guardian. So not general criminal active record. So it's not a CORI, which is the what's the difference, Carolyn? CORI is court
Criminal offender
record information. This is a criminal activity. So there is a difference.
Okay. And then the last thing was with regards to Rogers monitors. You stated that there can be a 1-year treatment plan. Is it frequent or is it common for there to be an order for less than 1 year, like a 6-month order or something like that? Or is it always that 1 year for the Rogers monitors?
For the Rogers monitor, it's a 1 year, unless there's a temporary guardianship, but it wouldn't be a Rogers. That would only be a temporary guardianship. But for the Rogers, it's going to be for the 1 year duration.
Actually, Geraldine, I also have a question. Because medical certificates and clinical team reports are so important, what would you say if the doctor signs on a different day from the exam? Which date is the date?
Oh, that's okay. Well, that's a good question, Carolyn. We're going to look at the examination date. It's okay. And it's even okay to have different signature pages. So if you can't get, like, you only get 2 signatures on the last page because the doctor is living his or her best life in Europe, but they send it via fax on their own page, that's okay.
And I also want to mention, for anyone that's on the call that works for hospitals or who is assisting folks on the medical side of it, getting together this documentation, please make sure that the dates of exams are very clearly listed on the front of the medical certificate or the clinical team report. When you're coming to a clinic with Geraldine, or when you're coming to the court service centers, that's what we're looking at to count out the periods. So sometimes sometimes people forget to fill out the exam date on the front of that medical documentation and just sign it in the back. And we know that likely it was on the same day. However, it is super important that that's written on the front of it.
And
Right.
also including, make sure that they sign, include their license number and specialty. That's also an important piece of information that is sometimes missed.
All right, so it doesn't look like there are any other questions. So thank you both to Geraldine and Carolyn for doing this wonderful presentation for us. As we said, that these PDFs will be made available for folks on Mass Legal Help, as well as the recordings on YouTube, on the De Novo Center's YouTube page. If you need additional help with civil legal issues, the Guardianship, VLP offers free civil legal aid for eligible litigants. The court service centers can be a big help with forms for folks who may need assistance. De Novo is also a resource available for folks with needs and legal needs and housing, disability, family law, and immigration, as well as counseling services. So please feel free to reach out to these, any of our organizations, as well as some of the organizations that are listed, for further help in the future. And we hope that you can share this information with anyone who may find it useful. Thank you all for joining us.
Yeah.
Thank you. Bye-bye.